that the court system was managed by a vendor who managed the caseload at that time. After May 2005, Clark County contracted with Tyler Technologies to implement the Odyssey case management system. We have a copy of the contract, and that Odyssey case management system implementation took place over a period of a year. It was rolled out in the family division, in the civil division, and in the criminal division. What happened is that the prior vendor and Clark County grew such a hostile relationship that the prior vendor refused to turn over any prior data that was already in the court system. We are victims of domestic violence. Our children are victims of domestic violence. All the evidence of criminal activity by the abusers was not rolled over into the Odyssey case management system. The reason we're bringing this to your attention, excuse me, I'm getting a little weak, is that we have been fighting this for 5 years, and we are powerless to get the family division to do anything about our children. Right now, the murder rate of Clark County children, this is a Department of Health and Human Services statistic by the state of Nevada, the murder rate of Clark County children is up 300%, 2009 over 2008. We would like to very much meet with you, Judge Gonzalez, because it seems like you have an opportunity to change this because you interact with family court judges. But we would like to have anyone in this room be educated about this matter enough to be electing out of office the incumbents who are allowing this to happen and not hearing about the domestic violence, and to elect in, not you, Judge Gonzalez, I certainly don't mean this directed towards you, but the judges that are not hearing our cases and not allowing us to speak in the court that they are cases of domestic violence. We are being called vexatious litigants because we keep filing motions to try to bring this before the family division courts. We have had martial law declared upon us because we have protested peaceably in front of the family courthouse, and we are powerless to do anything. Our question to you is, if you are elected into office or you remain in office, what will you do about this significant matter?
Candidly, I don't understand the question. I would love to address it. I understand that there were apparently some filings made early on prior to 2005, and when the court system switched over to Odyssey, something didn't get switched over. I really don't understand what it is that your organization or the group of litigants is asking of us. And it's important that communication be very clear, because if we don't know what the problem or the question is, we certainly don't know how to fashion a remedy. So if it's a matter of subpoenaing prior documents and then refiling them so they're in the system, then I would suggest that that be done. But if there is something specific that you're coming into a courtroom with, certainly a judge who is on the bench should be able to fashion a remedy to solve whatever that problem is. Thank you.
Thank you. This is John Eccles, candidate for Department F. As I understand it, it sounds to me like the Blackstone system operators have not been cooperating with either Clark County courts or Odyssey. Sounds like a logistical issue. The family court judges do have some power in that regard and meet on a monthly basis to try to address issues like this. The family court judges meeting is an open meeting, and so these matters can be addressed at the family court judges meeting on a monthly basis. That's probably the best, either through the Clark County Court Administrator or through the Family Court Judges meeting would probably be the best method by which to deal with this logistical issue. The Family Court Judges do have the ability, under certain circumstances, to consider prior bad acts by parties, even though we have these principles called res judicata, and you're not supposed to go behind the most recent court order. But if you can There are limits on that depending on whether or not the issues related to domestic violence were in fact litigated. Then you can go behind that court order if it was not made aware to the court. The other thing is that if you can show a course of conduct over a period of time that stretches behind the most recent court order. So if the documents are lost, that makes it difficult, but they may be able to be presented if you've been maintaining your files well, either through a course of conduct argument or because, in fact, that information wasn't previously provided to the court.
And I can give some insight since I've been at the judges' meetings dealing with this issue. We get literally millions and millions of pages of documents filed every year, and when we are going from a paper environment to a paperless environment, there were some concerns about the loss of information that's out there, very important information. Before, each judge had a confidential file that if there was a report by a doctor, if there was a police report alleging domestic violence, all that would be in the court's personal file. But when they switched over and they went to a paperless system, then the court has spent literally hundreds and thousands of dollars to protect that information. My understanding right now is down to a 1% error rate. And again, the court has spent thousands and thousands, hundreds of thousands of dollars to address this issue. And when you're talking about millions and millions of documents, when we're down to 1% error rate, that's pretty good. We actually have procedures right now for the judges that have their confidential file to have their own persons make sure that information is scanned. Now, even though they're doing it, that still means there's going to be some percentage rate of error there. And so that's what we're looking at. It's been very expensive, but it's very important information for us to have. I'd also recommend Steve Grierson. He's the court admin. I'm seeing a head shaking there. He is somebody who would be able to put it on the judges' our agenda when we meet. If you're not getting anything there, I would suggest Gloria Sanchez, who is the presiding judge. She'd probably be the next person. I can certainly check into it and bring it up in our discussion to see where we're at. What I would do is I would send a letter to Steve Grierson. Ma'am, just send a letter to him. Put your detail, your information in there, detail what your concerns are specifically, and CC me on that letter, and I'll make sure all the other judges get it, and they can look at it, and we can make a determination if you're having problems getting your information to the right people. That you can do, and once there's a detailed, specified, document that tells us what you're looking for, we can at least address it and see what we can do there.
We've done all that.
Then I don't know what else you can do.
Our children are just going to continue to.
Well, I can tell you in my department, domestic violence, and even though there are statutes here, there are laws that address as far as whether you would get primary custody versus joint physical custody when domestic violence is an issue. And I tell you, in my department, that's a very important issue that I address every day. So if you have one of your members coming into my department, I'm going to address that, and that would go not only for the women, but I have cases where the women are the ones committing domestic violence, and the men are entitled to those same rights also.